brothers and sisters, ladies and gentlemen, students and scholars, teachers and trainers, professors, professionals, medicinal learners, most honorable present traditional committee, respected ministers and managers, honorable doctors, directors, honorable advocates, supervisors, administrators, advisors, all my dear friends, those who are listening, YouTube channel creator. It is really nice time, nice place, nice action that we are appreciating our only Indian cultural land. Our great men, saints, freedom fighters, free thinkers, astronomers, astrologers, those who visited this holy Indian land, they addressed for oneness, equality and unity. Undoubtedly, they spread out the message of humanity. Let us discuss some important terms related to advocacy. Those who are going to appear in examination of advocacy, LLB third year. Today we will discuss from the first paper our first paper starts from the important terms related to the law. Very important question that you can write in your examination. Describe the Bharatiya Narik Suraksha Sanhita 2023. Behind the history, the Code of Criminal Procedure was initially enacted in 1882. After British India came under Crown administration following the 1857 rebellion. Since then, it underwent several amendments. Post-independence, the first Law Commission submitted its report on judicial administration, also known as the 14th report, suggesting amendments to the court. Subsequently, the Law Commission, reconstituted in 1961, presented the 41st report in 1969, recommending a revision of the code. Following its recommendations. The Code of Criminal Procedure Bill 1970 was drafted, but lapsed in 1972 due to the dissolution of Parliament. It was reintroduced as the Code of Criminal Procedure Bill 1972, and after being passed by both houses of Parliament with 125 amendments in 1973, the code came into force on 1st April 1974. The Act was amended many times to incorporate new provisions based on the present day requirements, and as is suggested by Supreme Court, provisions for plea bargaining, rights of arrested person, and requirement to give first aid or medical treatment to the victims of any some specified offence were included in the Act by amendments. But the system for dealing with crime still has problems. Millions of cases languish in courts. Millions of cases languish in courts. This immense backlog creates a ripple effect throughout the system. Several factors contribute to delays, including the opportunities for adjournments and appeals. Hence, the Bharatiya Nagrik Suraksha Sanhita 2023 BNSS was introduced in the Parliament. It was passed in Lok Sabha on 20th December 2023 and in Rajya Sabha in 21st December 2023. The President gave her assent on 25th December 2023. The government notified it to be effective from 1st July 2024. This Sanhita amends provisions on bail, extends the scope of property seizure, and alters the powers of police and magistrate, prescribes time limits for the completion of certain proceedings. This Sanhita gives the rules on the investigation, enquiry, and the trial of the offence. It establishes the guidance for enforcing the punishments outlined in the Bharatiya Nyaya Sanhita. However, the provisions of this Sanhita do not affect any special law or special jurisdiction provided under any other law. What are the salient features? Let us discuss the salient features. This Sanhita retains numerous key features found in the CRPC. The following are salient features of this Sanhita. One is preventive measures. It gives powers to judicial magistrate, executive magistrates, and also to police officers to take preventive measures. For example, it describes the procedure for security, for keeping the peace and for good behavior, maintain public order and tranquility. 2 is separation of powers. Even though some judicial powers have been conferred on executive magistrates, it follows separation of power and ensures ultimate control of the administration of justice is in the hands of the judiciary. 3 is ensure all complaints are registered. It provides for lodging aspirants of a complaint with the office in charge of police station for investigation. On his failure to act, he can send the complaint to his superiors. Further, it also gives an option to make a complaint. Its fourth salient feature is protection to the accused. It was enough provisions to safeguard to the magistrate the interest of the accused. For example, the accused may be enlarged on bail if such a person is willing to submit to restraints and conditions put on his freedom by the court granting bail. 5 is authority structure. By providing for the administrative control of the High Court over all judicial officers in the state, it ensures unity of control. As regards control over judicial functions, the High Court is given powers of revision to have control over the functioning of lower courts. Its 6th salient feature is fair trial. It provides procedure for a fair trial with an aim of delivery of justice and punishing the offender. It provides the procedure for appeal to the Superior Court. Excellent feature 7. Rights to arrested person. It prescribes rules for dealing with arrested persons, which reasonably protect his personal rights of freedom. For example, an arrest, his relative or friend are to be informed, right to have legal advice is given to him. An arrested person has to be medically examined before he is produced before a magistrate to ensure absence of torture in police custody. Number 7 is trial procedure. It prescribes different procedures for trial based on the severity of the offence committed. 9 is criminal courts. It provides for uniform organization and authority structure for the criminal courts throughout the country. Next and last salient feature is social security. It also gives power to the criminal court to order payment of maintenance to wives, children and parents. The Bharatiya Nagrik Suraksha Samhita 2023, DNSS has modified the law on the following matters. 1 is metropolitan courts. BNSS does not categorize courts on the basis of population and has removed the category of metropolitan courts and magistrates. 2 is assistant session judges. Under BNSS, the position of assistant sessions, the position of assistant judges has been abolished. B is forensic investigation. Under BNSS, crimes carrying a punishment of 7 years or more require forensic investigation. Experts shall visit crime scenes to gather evidence using mobile phone or other devices to document the processes permitted. States without forensic facilities can seek assistance from other states. Next, number 4 silent feature is the Bharatiya Nagarik Suraksha Sanhita 2023. Proceedings may be held electronically. All legal proceedings can now be held electronically under BNSS. This means trials, enquiries, and other legal actions can be conducted online. Additionally, electronic communication devices containing digital evidence can be produced and used for investigation, enquiries, or trials. 5 is electronic communication. BNSS recognizes that sending information electronically is a valid form of communication. Number 6 is use of handcuffs. Under BNSS, the use of handcuffs is permitted in a range of cases, including economic offences. This provision contradicts directives from the Supreme Court and guidelines set forth by National Human Rights Commission. 7 is voice samples. In addition to signature or handwriting samples and fingerprints, under BNSS, the authorities can now collect voice samples for investigations or legal proceedings. These samples can be obtained from individuals even if they haven't been arrested. Number 8 is police custody in parts. Like CRPC, BNSS also allows the police to hold a person in custody for up to 15 days. But it may be in parts during the 60 or 90 days period of judicial custody. But this provision may lead to denial of bail for the entire period. If the police have not exhausted the 15 days custody. Next, number 9 is half of the maximum period. As per the CRPC, if an accused had spent half of the maximum period of imprisonment in detention, he must be released on personal bond except in offences punishable by death. The NSS denies this facility to persons accused of more than one offence, since charge sheets often list multiple offences. This may make many under trial prisoners ineligible for mandatory bail. Next, number 10 is proclaimed offender. Under BNSS, if a proclaimed offender had pled to avoid trial and there is no immediate chance of apprehending them, the trial can proceed and a verdict can be pronounced in his absence. 11 is medical examination. Under CRPC, a police officer can, below the rank of sub-inspector, was having power to request medical practitioner for examination of accused under BNSS. It can now be conducted at the request of any police officer. Next, number 12 is plea bargaining. BNSS introduces a requirement that the police must apply for plea bargaining within 30 days from the framing of charges. This time limit can affect the effectiveness from the plea bargaining scheme. Let us discuss briefly some important terminologies that we use in courts legally. One is bailable offence. Section 2, Section 2, 1C of BNSS defines bailable offences as the offence that has been shown in the first schedule as bailable or which is made bailable by any other law for the time being in force. The first schedule of the BNSS is divided into two parts, wherein the first part deals with the offences given under BNS and the second part deals with the offences under other laws. Next, number 2 is summons cases. Very important term according to examination. Summons cases. According to section 2, 1X of BNSS, summoned cases means a case relating to an offence not being a warrant case. Summoned cases are punishable with a fine or imprisonment of less than 2 years. Summons cases are trial by magistrate. Under summons cases, it is not necessary to frame the charge in writing, stating the substance of the offence to the accused is enough. the particulars of the offence of which the person is accused are stated to him. What is the warrant case? It is defined under section 2(1)(z) of BNSS. According to warrant case means a case relating to an offence punishable with death, imprisonment for life, or imprisonment for a term exceeding 2 years. What is cognizable offence? Under section 2(1)(z) of BNSS, a cognizable offence, an offence for which cognizable case means a case in which the police officer, as per the first schedule or under any other law for the time being in force, can arrest the convict without a warrant and can start an investigation without the permission of the court. Cognizable offences are generally heinous or serious in nature, such as murder, rape, kidnapping, theft, chori, death, etc. The first information report (FIR) is registered only in cognizable crimes. 5 is non-cognizable offence. Under section 2(1)(0) of BNSS, non-cognizable offence means an offence for which a non-cognizable case means a case in which a police officer has no authority to arrest without warrant. The crimes of forgery, shooting, defamation, public nuisance, etc. fall in the category of non-cognizable crimes. 6th is judicial proceedings. As per the NSS, the definition of judicial proceeding in section 2(1)(m), the NSS includes any proceeding in the course of which evidence is or may be duly taken by court. Or in police report, it is defined under section 2(1)(p) of BNSS as police report means a report forwarded by a police officer to a magistrate under subsection 3 of section 193. 8 is public prosecutor. According to section 121(5), public prosecutor means any person appointed under section 18 and included any person acting under the direction of a public prosecutor. 9 is offence. According to section 2(1)(c) of the NSS, offence means any act or omission made punishable by any law for the time being in force and includes any act in respect of which a complaint may be made under section 20 of the cattle trespass. 10 is complaint. The term complaint has been defined under section 2. Under section 2(1)(h) BNSS, which means any allegation made orally or in writing to a magistrate with a view to his taking action under this Sanhita, that some person has committed an offence. It does not include a police report also. If after preliminary investigation it is discovered that the offence is a non-cognizable offence, then it shall be deemed to be a complaint. That is inquiry. Inquiry is the process of seeking information. Inquiry is the process of seeking information from a person who might give some relevant information about the matter in question. Inquiry is defined under section 2(1)(k) of the Bharatiya Nagrik Suraksha Sanhita 2023, referring to any inquiry other than trial under this Sanhita conducted by a magistrate or a court. What is investigation? Section 2(1)(1) of Section 2(1)(l) of the Sanhita defines the term investigation as all the proceedings conducted by the police officer or by any other person other than a magistrate who is authorized by a magistrate in this behalf to collect the evidence associated with the crime. At the beginning of any investigation, the crimes are identified as cognizable and non-cognizable offences, and then according to the nature of the crime, the investigation proceeds. What is crime? Crime is not defined in Bharatiya Nagrik Sanhita, Bharatiya Suraksha. Trial is not defined in Bharatiya Nagrik Suraksha Sanhita 2023. Generally, the trial can be defined as a type of inquiry with the object or to determine the guilt or innocence of the accused person. Warrant cases are triable either by the court of session or magistrate, whereas the summons cases are triable only by a magistrate. What is assistant public prosecutor? What is assistant public prosecutor? According to section 19 of BNSS, the one is the state government shall appoint in every district one or more assistant public prosecutors for conducting prosecution in the courts of magistrates. Two is the central government may appoint one or more assistant public prosecutors for the purpose of conducting any case or class of cases in the courts of magistrates. Three is without prejudice to provisions contained in subsection 1 and 2 where no assistant prosecutor is available for the purpose of any particular case, the district magistrate may appoint any other person to be the assistant public prosecutor in charge of that case after giving notice of 14 days to the state government, provided that a police officer shall not be so appointed. According to A, if he has taken any part in the investigation into the offence with respect to which the accused is being prosecuted, or B, if he is below the rank of inspector. What is victim? According to section 2(1)(y) of BNSS, victim means a person who has suffered any loss or injury caused by reason of the act or omission of the accused person, and includes the guardian or legal heir of such victim. Now let us distinguish between bailable and non-bailable offence. What is bailable offence and what is non-bailable offence, and what are the differences between these? In bailable offences, the seriousness of the offences is lower as compared to non-bailable offences. In non-bailable offences, the seriousness of the offence is higher. In bailable offences, bail can be granted as a matter of right. In non-bailable offences, bail is not a matter of right, but rather it is a matter of the direction of the court of law. In case of bailable offences, either the police officer or the court can grant bail. In the case of non-bailable offences, mostly the accused get bail through a court of law. Refusal of bail in case of a bailable offence shall amount to wrongful confinement. There is no offence committed if the officer or the court does not grant bail to the accused. Kidnapping, stalking and cheating, etc. are the examples of bailable offence. Theft, rape, murder, etc. are the example of non-bailable offence. Now let us discuss what is the difference between cognizable and non-cognizable. It is an offence in the reference of cognizable. It is an offence in which a police officer can arrest the convict without a warrant. In non-cognizable, it is an offence in which a police officer cannot arrest a person without a warrant. To is the incognizable, the police can start a preliminary investigation without the permission of the court or even without registration or fire. The police officer cannot start investigation without the permission of the court is non-cognizable. These heinous crimes like murder, rape, robbery, death, etc. are cognizable offences. These non-cognizable crimes are not so serious. Examples are not so serious. Example: forgery, shooting, defamation, etc. 4. Number 4. Cognizable victims can file an FIR or make a complaint to the magistrate. In non-cognizable, victims can only make a complaint to the magistrate. In cognizable, it is defined in the section 21G of the Bharatiya Nagrik Sureksha Sanhita 2023. In non-cognizable case, it is defined in section 21O of the Bharatiya Nagrik Sureksha Sanhita 2023. In cognizable, the police officer is bound to register FIR even without the permission of magistrate. In non-cognizable, the police officer cannot register the FIR without prior permission of the magistrate. It is a non-bailable offence. Cognizable is the non-bailable offence. Non-cognizable is a bailable offence. Now let us discuss what is the difference between compoundable offense and non-compoundable offense. What is non-compoundable offense? The nature of the offense is not so serious. Non-compoundable offense, as the nature of the offense is serious. Compoundable offense has charges made against the accused can be withdrawn. Non-compoundable offense has charges against the accused cannot be withdrawn. Compoundable offense impacts only to a private or single person, but in non-compoundable offense it affects both private person as well as the society at large. In compoundable offense, settlement can be done either with permission or without permission of the court. In non-compoundable offense, it cannot compound. The offense can only be twist. In compoundable offense, case can be filed by a private person. In non-compoundable offense, cases are filed by state. Compoundable offense, section 359 of the Bharatiya Nagrik Suraksha Sanhita 2023 contains the offences that can be compoundable offence. Any officer which is not included in the section 359 of the Bharatiya Nagrik Suraksha Sanhita 2023 are termed as non-compoundable offence. Compoundable offence under BNS theft, griefs, hurt, defamation, trespass, etc. Non-compoundable offence under BNS, murder, kidnapping, etc. Now what's the difference between warrant case and summon case? What is summon case? One is summon cases are those in which punishment will not exceed imprisonment for 2 years. In warrant cases are those in which punishment exceed 2 years of imprisonment. In summon cases, procedure of summon cases is dealt under chapter 6 from section 63 to 71. In warrant cases, procedure of warrant cases is dealt under chapter 6 from section 72 to 83. In summon cases, framing of the charges against the accused is not necessarily to be done. In warrant cases, framing of the criminal charges against accused person is mandatory to be done. In summon cases, it notifies the accused person that he is legally obliged to appear in court. In warrant case, it brings the accused person before the court who has ignored the summon has been duly issued to him. In summon case, it instructs to produce the relevant documents and others before the court. In warrant case, in general, it authorizes a police officer to bring the accused person before the court. Now let us discuss what provisions are made in regards to the appointment of public prosecutor and assistant public prosecutor in the Sanhita, who may be appointed as special public prosecutors. State the powers of senior police officers. and when public is bound to add to the police officer. What do you mean by Directorate of Prosecution? Let us go to the answer. A public prosecutor is considered as the agent of the state to represent the interest of common people in the criminal justice system. The prosecution of the accused is the duty of the state, but not individually the duty of the aggrieved party. They are appointed in almost all countries. The public prosecutor is defined in section 18 of BNSS. They serve as the basic principle of rule of law, that is, odi ultram partem. No person shall be punished without hearing. Odi ultram partem. Provision for public prosecutor is provided under section 215 of the Bharatiya Nagrik Suraksha Sanhita. Defines public prosecutor as a person who is appointed under section 18 of BNSS, and it also includes any person who is acting under the direction of public prosecutors. The functions of the public prosecutor differ according to their designation. One is public prosecutor, supervise the function exercised by the additional public prosecutor in Session Court and High Court. Chief prosecutor, supervise the function exercised by assistant public prosecutor in Metropolitan Magistrate Court. Additional prosecutor, conduct criminal proceedings in the Session Court. Assistant public prosecutor, they examine the charge sheet prepared by agencies and submit the acquittal or discharge. They also are responsible for the evaluation of evidence and filing revisions petitions. They also conduct the criminal proceedings in the court of Metropolitan Magistrate. Director of Prosecution, it is the head office. They exercise the overall control and supervision of officers of directorate. They also look after the account branches. Let us go through reasons for the appointment of public prosecutor. Whenever any crime is committed against a group or individual, it is assumed that it has been committed against society. It is the duty of the state to provide justice to any group of society or person who is affected by the crime in India. In India, it is necessary that the criminal justice system should function without the limits of the Indian Constitution, which means that it is necessary for the public prosecutor to act in accordance with the principles. Appointment of public prosecutors and additional public prosecutors for High Court. Appointment of public prosecutor is provided under section 18 of Bharatiya Nagrik Suraksha Sanhita 2023, which states as follows. One is, a person shall be eligible to be appointed in High Court as public prosecutor if he has been in practice as an advocate for not less than 7 years. However, it has been clarified by this section that the period during which a person has been in practice as a pleader or has rendered, whether before or after the amendment of this Sanhita, service as any prosecuting officer by whatever name called shall be deemed to be the period during which such person has been in practice as an advocate. 2 is the appointment or appointing authority can make the appointment only after consultation with the High Court. The central government shall appoint a public prosecutor and may also appoint one or more additional public prosecutors for conducting in a High Court any prosecution, appeal or other proceeding on behalf of the central government. Similarly, the state government shall appoint a public prosecutor and may also appoint one or more additional public prosecutor for conducting in a High Court any prosecution, appeal, etc. on behalf of the state government. The state government may appoint a director of public prosecutor, but he shall be functioning under the Advocate General of the state, who is the central government or the state government may appoint for the purpose of any case or class of cases an advocate who has been in practice for not less than 10 years as a special public prosecutor. The clarification regarding the period given in the subpara A above is applicable here also. Appointment of public prosecutor and additional public prosecutor for the district. A is the district magistrate shall, according to A, the district magistrate shall, in consultation with the sessions judge, prepare a panel of names of persons who are, in his opinion, fit to appointed as a public prosecutor or additional public prosecutor, and no person shall be appointed as a public prosecutor or additional public prosecutor for the district unless his name appears on such panel. However, where in a state there exists a regular cadre of prosecuting officers, the state government shall appoint a public prosecutor or an additional public prosecutor only from the among persons consulting such cadre. But if, in the opinion of the state government, no suitable person is available in such cadre for such appointment, then the government may appoint a public prosecutor or an additional public prosecutor from the panel of names prepared by the district magistrate as mentioned above. Next in B part, consistent with the above rules, the state government shall appoint a public prosecutor and may also appoint one or more additional public prosecutors for the district. Further, it is possible that the public prosecutor or the additional public prosecutor appointed for one district may be appointed also to be a public prosecutor for or an additional public prosecutor as the case may be for another district. The central government or the state government may appoint for the purpose of any case or class of cases an advocate who has been in practice for not less than 10 years as a special public prosecutor. Appointment of Assistant Public Prosecutor, Section 90 of Bharatiya Nalik Suraksha Sanhita 2023 states that the Assistant Public Prosecutor is appointed in the district for the purpose of conducting prosecution in magistrate court. The court may appoint one or more assistant public prosecutors for the purpose of conducting a case. If there are no assistant public prosecutors, then district magistrate may appoint any other person to act as the assistant public prosecutor. What are the powers of superior officers of police station? Section 30 of the Bharatiya Nalik Suraksha Sanhita 2023 says that police officers superior in rank to an officer in charge of a police station may exercise the same powers throughout the local areas to which they are appointed, and they may be exercised by such officer within the limits of the station. Public went to assist magistrates and police station. Public went to assist magistrate and police. Section 31 of the Bharatiya Nalik Suraksha Sanhita 2023 says that every person is bound to assist a magistrate or public officer reasonably demanding his act. One is in the taking of preventing the escape of any other person whom such magistrate or police officer is authorized to arrest, or two is in the prevention of supervision of a breach of the peace, or one in the prevention of any injury attempted to be committed to any railway, canal, telegraph or public property. Directorate of Prosecution. The provision for Directorate of Prosecution is provided under Section 20 of Bharatiya Nalik Suraksha Sanhita 2023. A person shall be eligible to be appointed as a Director of Prosecution or a Deputy Director of Prosecution only if he has been in practice as an advocate for not less than 15 years or is or has been a sessions judge. As an Assistant Director of Prosecution if he has been in practice as an advocate for not less than 7 years or has been a magistrate of the first class. Thank you all my brothers and sisters, ladies and gentlemen, students, scholar, teacher, trainer, professor, professional, all the listeners. I thank once again. Thanks all of you. Very nice time, nice place, nice action that we are appreciating our Indian law that was instructed, designed, outlined, drafted by Baba Saheb. Thanks, many thanks.